Okay, so we talked about language in the last session, and to use a really overworked cliche, the elephant in the room in a lot of our discussions about reforming jails and changing and addressing the jail crisis is really politics. I mean, ultimately, it comes down to a political decision, usually at a county level or a state level, sometimes a municipal level, about how far you want to go. What do you want to do? You want to build more jails? Do you want to spend that money on roads, infrastructure? What kinds of policies will encourage county authorities, municipal authorities to look differently at people who come before the court? That obviously involves police policies as well. We heard yesterday from the sheriffs who, I think it was Sheriff Taylor who said that the legislature, maybe it was Sheriff Amerson who said the legislature is killing us with all their requirements for referrals. So there's a political component, I think, ultimately to a lot of these decisions. And because we live, at least nationally, in a divided, polarized climate these days, it's hard to kind of separate what's really going on. One of the nice things about justice reform in general, on the state level in particular, and also on the county level, it's very much bipartisan. You don't really see a Republican and a Democratic approach now to justice reform. You see what's called smart justice, smart reform. Obviously there are exceptions to that rule, but most people are on the same page in terms of agreeing that we have too many people in jail and prison and that we have to change our ways to fulfill really our basic values as Americans and the promise of our system of fair treatment for all. So this session, I'm really pleased to have people who can talk to us from the political side of the spectrum. They're nationally known as some of the best folks in the business. We're really glad to have them here today. And I'm going to do this as kind of a Q&A, Charlie Rose type session. So I'm going to ask them questions. They'll introduce themselves a little bit, and hopefully we'll move the conversation along a little bit faster in that way, and then have you guys ask questions at the end. So I want to start first with Representative Chuck Efstration, who represents the House District 104 in Georgia. And his bio is in your packet, but just to cut to the chase, he's been very, very instrumental in Georgia in justice reforms in that state. He's among the things he's achieved is legislation to reform Georgia's early care system, and he's had something called the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act to assist caregivers and guardians. So he's worked on all sides, all areas of the system, and he's done some stuff on cash bail as well. So maybe, Chuck, I'll start with you to begin with, to talk a little bit about how you've been able, in Georgia specifically, to strike that balance between political balance to really move ahead in terms of the justice system.
Well, thank you so much for the opportunity. I'm so excited to be here with all of you today. In Georgia, this really came about because of the leadership of our governor, Nathan Deal, who is just finishing his second term this year. So this is our 8th year of criminal justice reform, and it was something that he spearheaded in his first State of the State address, where he said this was an issue he wanted to take on. It was before my service in the legislature even. He created the Council on Criminal Justice Reform. Ultimately, I became a member of that council, and we've had legislation each year incrementally addressing criminal justice reform in the state of Georgia, incorporating a lot. I was here for the earlier panel, incorporating a lot of what was discussed earlier: data, best practices, success stories from other states, and incrementally addressing it in different areas. So as a legislator and as a former prosecutor and criminal defense attorney, I carried a lot of the legislation. And to answer the question directly, as a political matter, there's been great success. Most of the legislation has passed with unanimous or close to unanimous support. In fact, I would say all of the criminal justice reform bills have been close to 100%. So
That's because you don't have some people that serve in the Kentucky legislature in Georgia.
I can't speak to other states, but I will tell you, politics can be very contentious many times, and luckily there's been broad bipartisan understanding and acknowledgement of the importance of these issues.
So let's talk a little bit about the reforms that have been achieved. Maybe you can give us a bird's eye view of what's been happening so far in Georgia.
So initially, there was sentencing reform, really for what you might expect. It's nonviolent property or drug offenses, sentencing reform in that regard. That shifted then to juvenile court reform, and just hitting the surface of a lot of this. From juvenile court, there was a review of probation and parole, as well as recidivist treatment sentencing, which had been in place from the real harsh penalties against crime that were imposed in law in the early 90s. Okay, and from there we went to ban the box, employment reform, many areas there. Then this year there was a transition to cash bail, and that was a major part of the legislation that was carried this year. So I'm giving the high overview here, but those are some of the broad policy areas that have been hit.
We'll get into them in a bit more detail, but Secretary Tilley, since you started the ball rolling in terms of where the politics are at, let's talk a little bit about the difficulties and the obstacles. John Tilley is a major figure in reform in Kentucky, in criminal justice reform. He's now head of the Kentucky Justice and Public Safety Cabinet, which, like Georgia, is an interesting sort of bipartisan unit that really operates in terms of developing a whole package of reforms, which I think is an interesting approach. And before that, he served 5 terms in the Kentucky House of Representatives, and he chaired the House Judiciary Committee from 2009 to 2015. Kentucky has been, like Georgia, it's a rural state. It's been well ahead of the game, many states, in terms of reforms. Tell us a little bit about how that's happened and what still remains to be done.
In 5 minutes, right? 5 minutes. So someone time me. This might not be possible. So I think Kentucky, beginning in 2010, I think it's sort of a story of some hope and despair, and I relate that to the overcrowding of jails in particular, because I know we'll get to that. But just looking at prisons and jails, and the fact that of the 2.3 million people in prison and jail in this country, almost 40,000 of them reside in Kentucky somewhere. So let's go back to give you a snapshot of where we were as a state in 2009 and 10 for that decade, which ended then. So at a time when all state prison populations and many jails were exploding across the country, Kentucky's growth rate in prisons was nearly quadruple the national average at that time. So when the Pew Center on the States and their Public Safety Performance Project put out the 1 in 100 report, Kentucky was its poster child for that kind of growth. Now, the good news is we are no longer that poster child because of some reforms, and I was proud to sponsor the bill, one of the first justice reinvestment bills. Georgia, we talked about some of the same people we know in that state. We were sort of, again, sister states in that effort. Georgia has now done more than we have since then, and that's why we haven't seen some of the same results. There are some great stories to tell. Again, as I referenced Sharice, the reason I know Sharice is because Kentucky is seen as the gold standard for pretrial in this country. That doesn't mean we have good pretrial detention rates. That's the confounding problem. That's the hope and the despair in one. But as we go forward, again, the thing that shaped the ability or shaped the debate was the fact that we couldn't run from that prison growth rate. So we did have a near unanimous passage, only one no vote, against our justice reinvestment package. Now, we're no longer growing at that rate. We don't have the 35,000 people in prison that was predicted. We have 25,000 today, which we manage as best we can. We are overcrowded in jails and prisons. Kentucky has this, again, under this banner of the good and the bad. We house roughly half of our state inmate population in county jails. I do not recommend that as a model. Louisiana does that as well. You all know where Louisiana ranks. It's probably one of the worst configurations I could imagine. Now, that's not to suggest we don't have good jailers and good jails doing good things. I want you to Google an article. Don't read it now while I'm speaking. I'm going to keep eye contact with all of you. Write it down for later. The New York Times did an article on Kenton County, Kentucky. We've partnered with the Kenton County Jail. That's in the greater Cincinnati area, right by the river. Beautiful little community. Northern Kentucky is a thriving area, very conservative area. But they've looked at and are now succeeding with our help and their great expertise on treating addicts in local jails in ways that might only be seen in larger state facilities. And they're using very innovative and advanced techniques, like using even opioid antagonists like Vivitrol to treat those with opiate use disorders on the way out, but having a very holistic approach to treatment behind the wall of the jail, and having units that do more than just treat the drug addiction, but treat so many of those problems, deal with the mental health conditions, deal with reentry problems like obtaining a job and getting a skill, learning soft skills. All those things we're teaching in reentry at the prison level now. So that was a great New York Times article written by our friend now in Kentucky, Sam Quinones. If you've not read Dreamland, how many of you have read Dreamland? Surely if you're in this room, go out today, and that's the second thing for homework, get a copy or borrow a copy of Dreamland. It will alter your thinking on how we got to this place where we lost 64,000 people to overdose deaths last year, many of whom cycle in and out of jails. This is all coming back to why we're here today. So Kentucky, I think, really our problem and our over-incarceration problem, our prison growth, was all driven by opioids. Ohio, Kentucky, the area around us, West Virginia, Appalachia in particular, was one of the hardest hit, if not the hardest hit area in the country. And we've been dealing with this longer than the rest of the country. So we're starting to see some progress while maybe the rest of the country is waking up to this nightmare. So, again, reforms. So against that backdrop, we built the need to treat people rather than incarcerate them. We understood that we could not arrest our way, as you hear all the time, out of this problem. So that spirit existed for a couple of years until things turned sour. And that's where I come into the despair, where politicians were reminded that, maybe it's easier to just increase sentence length. Maybe it's easier to not take any political risk when I'm up for re-election every 2 or 4 years. Maybe it's easier to be tough on crime and go against that national grain. And as I was suggesting quietly to my friend John to the right, it only takes 3 or 4 voices in a 138-member legislature in the House and Senate to derail any good efforts. So we've begun to roll back some of those reforms, even in the face of an administration under which I serve as head of a cabinet with 8,000 employees, everything from public defenders to the state police to prisons to juvenile systems. And a governor who, like Governor Deal, who has been proud to befriend and associate in this arena with Governor Deal. If you've heard our Governor Bevan speak, I'm the only Democrat serving. I'll just be upfront about that. He is. We all are. I'm the only Democrat serving in this Republican administration. And he chose me without ever we had never met. And he chose me because of the feelings I have about this, much like Governor Deal's, much like the rest of the country feels about mass incarceration, about the need to reduce our prison populations, about the need to improve reentry services and improve addiction and treatment services, improve the way we treat mental health in jails and prisons, the way to get people with mental illness out of our jails and prisons and into the proper treatment and community services. But our legislatures push back. And so when we're talking about politics, it only takes a few. So you've got to saturate. You've got to be outraged. Again, Ben Franklin once said the only way to get there is when those who are unaffected are just as outraged as those who are, right? And that's how we get there. So I'll leave it up for questions about that. But I'll just say politically, I could talk forever about that. But we've had several rollbacks and very few victories since then. But I'll leave it at this, we have been very innovative and have been mentioned on a national level recently about our work in reentry. Vice President mentioned this, Sam Quinones mentioned the work in Kentucky, and that is one thing we do hang our hat on at the moment.
Well, keep the mic for a second, because I want to ask you to deconstruct a little bit about that pushback. Why is it happening? I mean, has the public stopped being sympathetic? Kentucky, if you look back at it over the last decade, has had enormous achievements in terms of its willingness to go the extra mile in terms of reform. So what's happening? And is that reflect or indicate perhaps some of what's happening in the areas that these folks come from as well?
I think I did mention it. It's hard to do in 5 minutes. I did mention, and I can go into detail later if there's a question. But I think we pride ourselves on some of the most innovative drug policy in the country as well. We've, as a state that is a conservative red state, even though we had a Democrat governor that just a few years ago for 2 terms and a Democrat. We were the last chamber in the South to be controlled by the Democrats, the House. That flipped 2 years ago. And so we are now, again, an all-Republican legislature. That said, we've been incredibly progressive and innovative in drug policy. But the reason, to your question, I think it's complicated why we've been derailed. The public sentiment is not that different than the rest of the country. In fact, polling shows that we're very normal when it comes to the need to move to reduce prison populations and jail populations, offer more treatment. I think again, that ground is soft for that. But all it takes is a couple of tone-deaf legislators. Let's be honest. You've seen that at the state and the local and the national level about people who are going against the grain right now. And so I think, and again, I'm not at a point. I'm just going to be blunt. If you ask me a question, I'm going to be fairly blunt with you because we don't have time. I think, again, this is odd, but since I'm in New York, the great American composer Leonard Bernstein once said, the way to succeed, the way to accomplish something and get to a goal is to have a plan and not enough time. We don't have enough time in this country. For Christ's sake, 1 out of every 3 women incarcerated in this world is in the United States. In Kentucky, 33,000 children are impacted by incarceration, the second highest rate in the country. We have a growth rate for females 5 times that of our males right now. We continue to put women in prison at a higher rate than men, at least in terms of a growth rate. So even against this backdrop, we've tried to be pro-family about this. There are enough disparate voices, Stephen, to push back enough, and they're in leadership positions. And when the balance of leadership politics hinges on a couple of votes, maybe the leaders in the Senate or the House are for you, and maybe you have enough votes in one chamber, but all it takes is a couple of key votes in one chamber to completely derail or stop any significant We had 22 policy recommendations after a 2-year project that came to our legislature. The legislature rejected all 22. And these recommendations are not, it's not rocket science. I mean, these were all good, common sense things. One of those was eliminating money bail. We have the groundwork, we have the infrastructure to do that easier than most states. Rejected that. That still has momentum, by the way. That will come back. I think we'll get something done.
So I want to come back to those things in a minute and the political climate, but I want to go to another voice from another part of the country, John Bauters, who is Director of Government Relations for Californians for Safety and Justice, but actually wears several hats. Not only is, you may wonder, California rural, but yes, John is from a rural area in California, and he's not only elected member of his local city council, but he is the mayor. So we're very pleased to have a mayor sitting with us today. And John, you want to take, when you look at reform and the jail crisis, you actually want to take it a little bit further than just eliminating money bail and eliminating and changing pretrial release. So tell us a little bit about what your organization does and what you're hoping to achieve.
Yeah, thank you. Pleasure to be here today, and as someone who grew up in a rural community, didn't discuss these items like we do right now, I appreciate the work you're doing to educate the public on this issue. In California, a lot of people would look at the California legislature with a supermajority of Democratic leadership in both sides of the legislature and presume that that's an easy role for criminal justice reform. And although in the last 10 years California has been a national leader in criminal justice reform, it's important to know 2 things about criminal justice reform, both in California and nationally. One, the attitudes toward criminal justice reform, like many things, are cyclical. And so as my colleagues up here were just speaking to, attitudes about reform and the aptness of reform evolve with time, and narratives are what change and what catch up with people in terms of how they perceive the need for reforms. Everything from jail and prison overcrowding to whether or not a person who has a felony conviction should have a right to vote. In California, despite having Democratic majorities, it's those narratives, and it's the narrative of what it means to be incarcerated that influence the decision makers the most. So if I could leave you with any one thing today, I don't bury the lead generally. I would give it to you up front. There's several paradigms and several presumptions that I think come to having a discussion about public safety, jail crowding, and prison overcrowding that I think you should question every day where you are locally. The first is, does this actually advance public safety? For a long time, and for many people, we hold on to the presumption that only by incarcerating people can we actually improve public safety. There's a lot of demonstrable evidence out there that suggests that that's actually counterintuitive to public safety. And we've heard a lot of people talk about bail reform, but in California we've looked at a number of other things in addition to bail reform, which is what we're working on now. We began with realignment. We actually began moving people from prisons to jails, mostly because of the nature of the environment in which a person was held has an impact on their social status, their psychiatric well-being, and their likelihood of returning to incarcerated status in the future. Second, we had Proposition 47 in 2014, which further reduced a number of crimes from felonies to misdemeanors. These were crimes that were nonviolent, non-serious, non-sexual offenses, things for which a felony term of imprisonment in a state prison didn't really match the nature of the crime. And what we did with that, I heard one of the prior panelists, I think, was mentioning this reform. We actually took the savings that we gained by putting fewer people in prison, and we reinvested it in community-based mental health programs, in substance use and diversion programs, things that actually provide treatment and care for people, but will reduce the likelihood that those people return to jail or prison in the future. In 2016, we passed Proposition 57, which increased eligibility for parole for inmates who had served the base sentence. There are a lot of terms put on people for the duration of their sentence that are what we call enhancements or add-ons because they are either affiliated in a gang database or they have other conditions that a prosecutor uses, generally with wide-ranging discretion, to keep a person incarcerated longer. These are a series of examples of how we have worked as a state to reduce the jail and prison population overall while not harming public safety. You can't simply remove a person who has committed a crime even without giving them the tools or resources they need to be a habilitated person in the public. The other thing that I would ask you to challenge is, what do victims really want? Our organization works very closely. We have 6,000 members in the Crime Survivors for Safety and Justice Network in California, and we work to lift up the voice of victims in California. The paradigm has often been the white woman clutching her pearls in the Berkeley Hills. That's the crime victim of the day. The reality is that it's most commonly an African-American male between the ages of 16 and 25 who is a victim of crime. Yet we don't put that face behind the narrative of crime victims, and the reality is that hurt people hurt people. And so when we take away the voice and the franchise of people who are actually victims of crime in their community, and we decentralize that narrative away from what crime victims need, we actually lose the sense of justice we're trying to promote through the carceral system and the alternatives to incarceration. And so by giving that narrative back and by basically giving people the voice that they actually deserve, we find that on a ratio of anywhere between 2 out of 3 or 3 out of 4 people nationally who have been victims of crime prefer healing, treatment, reconciliation, and repatriation with the community over criminal punishment and incarceration. So your criminal justice system isn't doing what crime victims actually want. And it's perpetuating a cycle of violence within our communities that keep communities of color, disadvantaged communities, and other communities apart from one another. It destabilizes their family situation. It makes them less likely to be homeowners or be housed. It actually decreases employment opportunities. It creates anxiety in children. It does other things that impact the health and well-being of our community, which I would ask you to lump into the narrative of what is public safety. So if you're looking to discuss community safety, community health, those are things that have to come along with this narrative of public safety. Speaking specifically to what we're doing right now on bail reform in California, I mean, we're basically, I've heard a lot of people this morning talk about it, so I don't want to kind of reiterate all those points, but really the underlying premise is, do we have a system that is based on non-safety related means analysis? Are we going to decide that you're safe because you can afford to pay bail and you're not safe because you can't? And why do we use jail and pretrial detention and the resources that come with that? Why is that the most appropriate tool for a person who's not been convicted of something to be held in an incarcerated status? And so those are some of the overarching primary questions I just want to throw out there as things that I think when you go back to your home community, these aren't things that coming from a rural community growing up we ask enough about our local leaders, because there's this underlying presumption that only sheriffs, only police officers, and only the county jail can help make the community safe. And the reality is that there is a lot of evidence to the contrary.
So the reforms we're talking about here in California, in Kentucky, in Georgia, which have been very effective, but they've been insulated in many ways from the way the national debate has been going. And I'm wondering whether each of you feels in some way the national climate. We've been hearing this tough on crime rhetoric out of Washington for the last year and a half, 2 years, whether that has begun to impinge upon your ability to really effectively make reforms, whether that you've found yourself running into headwinds in terms of public opinion that you didn't have before. Maybe, Chuck, I'll start with you.
It's not something that I've seen whatsoever. I think there's a real understanding from the public that has come about probably initially because of accountability courts. And just briefly, drug courts in Georgia, we have operating under the influence courts, veterans courts, mental health courts, parent accountability courts for child support issues. The whole court system here is about ensuring that the participant remains compliant with the court's order. And the stories that have come from that, I think, covered in large part by local media, talking about specific instances within the community where somebody who was on a difficult track was able to address the underlying causes of either the criminal charges or or whatever else was going on to right that, and that it wasn't because they were simply thrown in jail, put in confinement, that was addressed. Those success stories, I think, have been very powerful. There also are, I think in the current climate, everybody knows someone in their family who's maybe struggled with addiction and who has been in similar circumstances where understanding from the court system is necessary. At least from my perspective, in carrying a criminal justice reform bill this year, so this would have been in March, not too long ago, the current political climate has not in any way prevented a Republican from carrying this legislation effectively and the General Assembly passing it unanimously.
A couple things. I just quickly follow up on a point John made about victims, and I could not agree any more with what both of these gentlemen have already said to this thus far. On the victims point, though, back to since we're talking politics for the moment and headwinds generally, if 2 out of 3 victims do believe in, rather than sort of getting their pound of flesh, they believe in more of a holistic, restorative approach to justice, that is true. The problem is 1 or 2 victims can come and testify before a legislative committee and completely derail a criminal justice reform bill. And if that chairman allows a circus-like atmosphere and allows testimony that is unrelated to anything you're trying to accomplish, then that's so you've got to have this incredible momentum and buy-in, which is clearly happening in Georgia and California right now, and not in our state, even though the vast majority are for it. So it's confounding. So to your question, does the national rhetoric, has that impact? I think we had the headwinds long before the national rhetoric began. And again, I'll reference Sharice again. She and I just happened to sit together at the White House, and it was almost surreal to see Van Jones on the stage with Governor Perry from Texas and people we've worked with, and then President Trump and Vice President Pence was there, and Jared Kushner and Jeff Sessions was in the front row talking about the importance of good reentry policy and second and third chances, maybe not fourth chances, as the president said, but maybe it was kind of a lighthearted moment. But everybody did come together in that moment. Despite your politics, so how you feel about anything else, there is something in this window. I didn't think it would be open this long. I felt the window is open for criminal justice reform in a way. Again, 25 years I've done this in criminal justice. I've been a prosecutor. I've been a defense lawyer. I've worked in every facet in mental health. I've worked in drug addiction. I've been in the legislature. I've seen this. I thought this window would be closed by now, and it's not, despite the national rhetoric. I think states are moving forward with policy. States are the laboratories of democracy. Things happen at the state level. They're not going to happen in Congress. The First Step Act, Representative Collins from Georgia, we actually, with the White House, I was on calls with about 15 other people for months to help build the principles of reentry. And the idea is this, Steve, so to the question, I think some would say, well, why are we just focusing on reentry? What about front-end reform? What about getting people out of prison or diverting them? What about even pre-arrest diversion? And then what about post-arrest diversion? Or what about shorter sentences? What about treatment over incarceration? Why are we just focusing on reentry? Well, to the point that was made at that forum, we've talked a lot about it at the federal level for a long time, and nothing has happened. So why not take at least one bite at that apple with something good? Get people back to work. Get them treatment. Follow them. Give them individualized case plans when they leave prison rather than a bus ticket and a pat on the back. So isn't that a start? And again, I'm for the front-end reform, trust me. We have far too many people in prison, whether you believe in Cut 50 and Van's effort. I frankly think, Jeremy Travis obviously likes to say that the number of people we have in prison in this country is profoundly un-American. You all know Jeremy, I'm sure, if you're John Jay, right? Former, I know. And I just looked around the room and I was trying to gather how many people. And I was just with him a month or two ago, and he used that again. And I have been stealing that phrase from him because it's always struck me that way. It's profoundly un-American that we have the number of people in prison and jail that we do. And so I still think the public gets it. You got to make them really get it, though. I'm going to not overquote you, but there's probably only two people in this room who know who Eric Sevareid is. Anybody? Come on, Stephen, you know Eric Sevareid. Anybody over 55-ish? I'm almost 50. Legacy. Well, Eric Sevareid, look up the guy was an eminently quotable journalist and broadcaster, but he said never, how did he say it? He said never underestimate the intelligence of the listener nor the lack of information he or she has, is what the quote goes, right? And so you have to inform people. I mean, as a mayor, you know that once you go to a civic group and you explain what you just explained to them, they get it, right? They buy it. The business community buys it. The constituents buy it. But you got to explain it.
Let me follow up on that last remark. The level of potential for private partnerships in terms of reform seems to be hold really promising opportunities now, and I understand that it's happening a little bit in Kentucky, and this may be an alternative. Tell us a little bit about that.
Yeah, I'll be quick about it. So this mic, I'll let you keep the mic.
You can use that mic over there.
Or that.
We do have three. So.
That's right. Leaving a mic on the table. In Kentucky's business community through the Kentucky Chamber was one of the first in the country to step forward back in 2009 and 2010. It was really unique for the business community to say, listen, we have too many people in prison. In Kentucky, it was decimating the workforce. Decimated. So incarceration and addiction decimated the workforce. So Kentucky's had record economic development lately. We're positioned. Amazon just put 10,000 jobs. They're not the Amazon that everybody's vying for, the 50, but we got 10,000. We're pretty proud of that. And we're just growing at a rate. We cannot fill the jobs we have. 200,000 open jobs. And our Kentucky Chamber president stood with me and said, we have decimated our workforce. And so they have taken an active role since about 2009 and 10 and have stayed just as active since then. But beyond that, we have reached out through our reentry division, which we've rebuilt in the last 2 years under the Department of Corrections. In Georgia, they separated, my friend Michael Nail separated community supervision from corrections, which I think is a novel concept and a good one with the help of the Pew Center on the States. They did that. I looked at that. We decided to keep it in corrections because we want to begin reentry on day one in the prison. Right? And you want to then partner with the private community, bring them in to teach them job skills, preload individualized education plans for a plant that may be nearby. For any kind of, it doesn't have to be any kind of particular work. It just has to be work. It could be, there's tremendous potential and talent behind these walls.
This is one of the tenets of the White House plan.
This is exactly. But what we've done is we've partnered with very, very localized efforts. We've partnered with anybody and everybody who wants to come forward. Faith-based efforts, just civic efforts, private sector business opportunities. And we've, coding. Microsoft has come in. We've gotten others to come in and help us. We're teaching coding to out-of-work coal miners along with those behind the wall in our East Kentucky prisons. That was on a 60 Minutes piece, not to give you any more homework, but that was a fascinating piece. BitSource is the name of that company. In any event, so they've come to us and say, how can we help? So they see this decimated workforce, and they see it going to prison and jail, and they're saying, how do we help? How do we train these folks? How do we get them jobs? How do we get them transportation? How do we do drug treatment in our own companies? rather than having a zero tolerance policy, which it's their right to do. There's a huge employer that just came in and said, I'm going to have a zero tolerance policy. I'm going to pay this incredibly high wage, but I'm going to expect that if you test dirty one time, you're out. Some companies have said that's not realistic. Let's work with that employee we've invested in. Let's get them into treatment, keep them on the job. And what is addiction if it's not a disease of relapse? So let me make one final point to follow up on something that I think is an excellent. I love specialty courts. If run well, like they are in Georgia, they do good work. There are some, we'll have another discussion sometime, there are cons to specialty courts. Having said that, one of the things that is difficult on addicts in the criminal justice system is we put conditions on addicts that we as sober people couldn't satisfy, right? We're going to put 11 minimum conditions on you, Mr. Tilley, and we're going to expect that you come back to this courtroom. We heard that a little bit just a couple hours ago, right? We expect you to come back here every month or every week, or we expect you to go to your P&P officer every week, and you've got to go here and there. And I know you don't have a really good place to live, stable and safe housing, and you're still trying to get back on your feet financially, and you've got kids and you've got a family. We're going to expect all this out of you, and then we are surprised when this person fails. And then what do we do to them? We send them back to prison. So what we've done in Kentucky is we've tried to say, and I've tried to rebuild this, or reshape the culture in our 600 probation and parole officers and say, turn this, and rather than trying to trail them, nail them, and jail them, why don't you try to help them succeed? Help the recidivism rate. Make your job easier. Befriend them. Try to help them. Be a mentor. And then also engage the private sector with mentors, because government cannot do it alone.
So reshape the culture. Most Americans haven't been aware of the jail crisis, particularly the rural jail crisis, because that's why we're here. But I know, John, one of your interests in particular is looking at how jails and prisons become part of the justice system, and the roots of which originate not just in crime, but in deeper areas like poverty. And I'm wondering how you and your organization feels we can deal with that and address that beyond just the quick fixes in terms of jail overcrowding, building more jails, or reorienting our resources to other things.
That was a great question. I think one of the first things we have to do is acknowledge why we have jails and prisons to begin with, and why we have jail and prison overcrowding. And if you go back, unfortunately, in our country's history, it's due to institutionalized racism. And if we don't have that conversation, we can never really get to the root causes of why we incarcerate people and why people are of disparate means and different opportunities in our country. You can follow the black codes, the Jim Crow laws. You can follow everything that was cut out of the Civil Rights Act. You can follow everything that happened keeping people from getting home buyer loans, redlining, urban renewal. There's 1,000 different ways in which this country historically has segregated itself along racial and ethnic lines in a way that has actually contributed to mass poverty and mass incarceration. And that's an important story that has to be told as part of the context for why we are dealing with so many people in jails and prisons today. It is convenient for many people who feel that the status quo is the right way to go to say, well, more black and brown people commit more crimes. That is absolutely not the truth. There is disparities in the administration of justice. There is disparities in the way in which we actually police and operate our criminal justice system. And so if you're going to make structural changes and you're going to look at things beyond just how do we end jail overcrowding, you have to look at the other places in which inequity exists in our current social systems. So public safety reform is not limited to questions about policing or jails, or should there be body cameras, should we change use of force practices. Those all are absolutely necessary components of criminal justice reform and lasting, meaningful impacts for communities that are impacted disproportionately. But we also have to look at the gender gap on wage earning. We have to look at why do African American women make 3 times less than white women working the same jobs. There are total challenges that we have that are systemic to the culture of our community, and they're more pronounced in rural and more segregated parts of our country. They are more pronounced there. And that's a real challenge because that's not a conversation that a majority of people are comfortable having. It's a very hard topic to bring up. And so as somebody who's paid full time, as I am, to essentially help create narratives. I work with people in the media in California to help explain to communities that may be more conservative, maybe rural, may not have sat down and had this issue at a council meeting come up like they might in Oakland or Los Angeles. These are issues where you have to use language that people locally understand, to have a conversation that people can engage on. It's very easy to turn people off, people who look like myself, off to a conversation about this issue and say this is just a bunch of progressive liberal BS if you haven't really given them a context to understand. And so what I find to be the most helpful thing is I work very closely with impacted people directly. And oftentimes you need to actually have the narrative come from a person who's living the experience of what over jailing, over policing, over incarcerating our community looks like. It surprises people when somebody who they don't expect walks into the legislator's office and talks to them about their lived experience with mass incarceration. When a U.S. veteran in a rural community comes in and says, I've lived under the freeway overpass in Redding, California for 12 years because I suffer from PTSD and I can't get housing because as a consequence of my PTSD, I have commit a series of crimes of poverty or crimes of my health condition that have made it impossible for me to get employment or impossible for me to get housing or other types of assistance. In California, there are over 4,000 collateral consequences, civil consequences that come from having a conviction or a record. So while I agree with John that in a lot of places in this country, the first step is whatever we can get, right? Whether that's reentry assistance or other programs. In California, we are trying to move that narrative where we all hope it would go, I think, which is to that pretrial space, to that pre-arrest location, where we can sit there and say, okay, there's a person who has either a demonstrated history of engaging in conduct that's unhealthy to the community, but what are we doing proactively to help ensure that doesn't happen again? Why do we wait for that person to show up in front of the judge's bench to be determined what's going to happen to them? And when we do sentence that person, have we actually made it possible for them to be rehabilitated? In most cases, the answer is no. Going to a county jail does not change a person's behavior. It does not solve addiction. It does not provide mental health care for a person. It does not make their family more stable or financially secure. So how do
Makes them worse.
Yes, it absolutely does. It absolutely makes it more likely that they will live in dire poverty for longer. And so those are family narratives. Those are about keeping families together, about securing the future of children, and those are narratives that people in rural and conservative communities identify with. And so we try to kind of bring in the various different components of, it's less important what the actual reform is, in my opinion, than it is what is the narrative and who are we messaging to.
Chuck, do you want to weigh in on that? System change, culture change? How do you get there?
That's all right. I think that first of all, I'm really coming at this from a perspective of seeing what I would classify as very effective criminal justice reform that we've had in the state of Georgia. So we have had many programs that have been maybe outside of the classification of criminal justice reform, I think answering the question here. For instance, this year we fully funded education, K through 12 education, for the first time since the funding formula was set in the early 80s. And we have also had a great expansion of technical college opportunities in coordination with the Department of Corrections. So within our prisons, we've had technical college certification so that upon a prisoner's release, there are employment opportunities immediately available, and they are state certified to practice in that area already as soon as they get out. Just seen, and there are incredible testimonial stories about that. But as far as the broader issues that maybe are in play, I think that that's an important discussion that's maybe a little more broad than some of the specifics in the criminal justice reform bills that I've carried. So if it's all right, I'll just kind of highlight some of those. For instance, this year, as part of the legislation, it clarified that in Georgia law already, police officers had some wide discretion. If there were certain low-level offenses that were observed, actually a citation could be issued. It just wasn't occurring in practice. So there was the legal latitude to do so. We made it very clear that for specific offenses, the police officer could simply issue a citation, not arrest the person who would otherwise be charged for this low-level offense. That's a step we didn't even enter into, the bail discussion then, that we had earlier, because we've avoided that entire process. The person just will have to show to court with the date provided on the citation. Additionally,
were police chiefs okay with that?
yes, I mean there was support from the police, from sheriffs, from law enforcement. I think that
we actually mandated citation only in 11. I wish you luck. I'll share a number with you when you're done in a minute. That's pretty groundbreaking. We've studied it since then. If you want to, go ahead, finish. Or I can just do it quickly and give it back to John. We did that in 11. We mandated certain citation only. If counties came forward and said we have too many people in jail, we need, for these low-level nonviolent misdemeanors, citation only. So that took into account several of those. We still need to reclassify. We have a long way to go. What we found, we discovered in year one, the fear was that those people released, one, would not show up to court, right? And they'd have to issue bench warrants, and the system would, just implode. So there was all this fear and hand-wringing over that. The second thing was these people on release would commit more crimes. Neither thing happened. In fact, the public safety factor went up a little bit. Actually, things got better, counterintuitive. Secondly, they didn't show up to court in the same rate. They actually showed up at a better rate than they had before, slightly. Now, that's kind of gone up and down, but no major problem. But every year, 15 to 22, 23,000 fewer arrests every year. Public safety is impacted in a positive way, and you reduce that jail population. Since then, they've rolled back a few of those. They want discretion to arrest people, but they've always had some discretion. If the person just went off the rail for one of those and didn't follow their instructions or was a danger to self or others, you could arrest. So we've kind of made some tweaks along the way, but I applaud that, and I'll send it back to.
So in 2009 in Georgia, there was an expectation that the prison population would increase at 8% between 2009 and 2017. And actually what we saw is a plateau or dip in the state prison population. And if you just look at entry into prison year over year, there's actually been an 18% decrease in the state of Georgia over that period of time.
Go back to
So this is 09 to 17. It's 18.6 overall decrease. For African American males committed to prison, the decrease was 29.7%. For African American females, it was 38.2% over that period of time. Currently, the number of African Americans committed to prison in Georgia in 2017 is at the lowest level since 1987. That's total numbers. So as far as specifics as to what's been seen, we have some hard numbers that have been observed as a result of these reforms that have been put in place. I could talk on and on about the specifics of the policies and just the great things that we've seen, but to address some of the points that have been raised, as far as reminding individuals that you have court, you have to show up for court. So we saw there was a problem where failure to appear warrants, bench warrants, were being issued because a citation had been written, but the person forgot and didn't show up to court. And then all of a sudden there's a bench warrant with a driver's license suspension as a potential consequence. So what we started doing is we said that if you miss court under those circumstances, the clerk of court actually sends a postcard to the address, reminds you need to come and address your case, or file paperwork if you want to litigate it, and that's fine. You can contest it. We're not eroding due process, but it effectively put everything on pause for 30 days to allow that person to take care of that. We've seen tremendous benefits because ultimately local governments are not interested in having these low-level offenders, or I don't even know if you would characterize it as that. It's a person to whom a citation has been written, incarcerated for several days or longer, waiting to appear before a judge to explain why he or she just forgot, the date that was provided on the citation. These common sense measures don't require, in my view, don't require an extensive policy debate. It just, any legislator looking at this on the front end says, this makes sense to me. I can understand why this should be the case, and I can explain it to the electorate when it comes time for an election. So as a former prosecutor, I think there have been a lot of broad policy ideas really discussed, and I love that. I just take so much in. But here are some things that I've really thought about just briefly. I think that, first of all, the time period in which a disposition is reached is there has to be a good in-between spot. We heard in the panel earlier about, if you've just met your client as a defense attorney, case is brand new, it's difficult to have a disposition right then. There hasn't been time to investigate the case, and that makes complete sense. But also the opposite of that, cases going on and on and on for really no reason when everybody knows the facts. I mean, it's not, the allegations are what they are, the defense is what it is. Let's get on with a resolution or a recommendation. I think that that's a really crucial, important area, because if you have people who are on bond for a long period of time and are successfully living in society, that is a real difficult thing after a case has been pending for several years, to be discussing harsh consequences potentially mandated by statute for those criminal offenses.
So what I'm hearing, I want to go to questions in a second, but what I'm hearing is that what seems to be working in Georgia and also in Kentucky is step-by-step practical approaches, not necessarily the systemic approach that John wants to see in California.
Well, I think I would agree with that to an extent. I think that it's with a systemic view overall, but I think that there isn't just one solution to the problem. I think that it's a broad area. And the final thing I'll mention is, judicial discretion has, I think, for many years been really encouraged, particularly in sentencing, because not every case is the same. But the difficulty is some of what was raised earlier today, that when there is broad discretion, or you're seeing lenient or harsh judges, or there are all these different factors that in some ways prevent a case from being evaluated simply on the facts and the criminal charge. And in some ways, a legislature or elected officials can be the ones who simply make that policy decision. They say, okay, for your first offense for this crime, if you are convicted, this is the sentencing range that we're discussing. Just me speaking here. I think that that's really important, because then it gives that guidance. And earlier there was discussion, which I think was very appropriate, about how some judges say, well, I'm worried. The judges in Georgia are elected. The judge is maybe concerned, I'm going to have to go before the voters. In some places, the judges run in partisan races, okay? And
we elect jailers.
Which I don't know is a good idea. But my point here is, then the legislature can absorb some of that discussion. They can say, well, a policy decision was made at the Capitol that this is what a case range should or shouldn't be, and that's the reason that we're now limited.
So here's my last question I want to throw out to you guys before we move to questions. Is it time to rethink the election of judges and prosecutors?
I believe that elections of judges and prosecutors are a good thing, but I do not think partisan elections. I think that judges and prosecutors should run nonpartisan. That's my perspective on that.
Mixed feelings on that. I would like. I've heard it discussed so many times and debated, and I really don't feel qualified. I'm one who tries to base decisions on the science and what actually works, having a good evidence base. And I've heard too many pros and cons of both approaches. I do think this. I think having elected jailers and elected judges and we elect everything with dog catchers and the first reaction is you've got to be accountable to the people. And being accountable oftentimes doesn't always represent the best policy. And so I might lean toward a system where we gave judges some cover to make good decisions. I think more judicial oversight might even be necessary. But I'm sort of still out there trying to find my way in this debate. I got to be honest. I'm not trying to evade the question, because I don't mind taking a controversial position at all. I actually brought needle exchanges to Kentucky, so first southern state to have a comprehensive approach. They thought I was crazy. Now we have 50 programs, by the way. So I'm not evading a controversy, but I see both sides of the coin.
Fair enough. John?
Yeah, I think there's a preliminary issue for my answer, which is, do we change the amount of prosecutorial discretion we give prosecutors? I'm a little less concerned about a nonpartisan prosecutor election if we give discretion in California, at least, back to judges where it has been slowly eroded away for 3 decades. I think that judges are supposed to be beginning my legal career working for a court. They're supposed to be the arbiters of objective, impartial analysis. And I think that having run in my own elections and having supported people in elections and having lobbied ballot measures across the state of California, I do have concerns about judges being elected. And I think that there are ways, I agree with additional judicial oversight. I think judges should be given additional discretion to basically provide equitable relief to people in the cases before them. I also think we should have limits on how long people serve as judges, so that we don't have long-term problems related to judicial shift.
Okay, let's move to questions. We have about 10 or 15 minutes, so we have a mic. Someone can take around the mic. There's the mic. And again, tell us your name. Just do it yourself.
Hi, my name is Whitney, and I'm actually in Mississippi, and my question is directed to you, but anybody can chime in. When I was looking at some of the reasons for lengthy trial delays in Mississippi, one of the things that kept coming up was that we only have part-time public defenders. They're all based on contracts, and I know that Kentucky implemented a full-time public defender system even in rural counties, and I just read that. I didn't really go into the issue deeper, but has that really helped cut down on pre-trial detentions?
The answer is yes, and I think, again, as far as a number dating back to when Kentucky took that step, I could not give you. That's an excellent question, and let me say this. There are studies after studies that would tell you that a robust public defense system, it actually has incredible benefits. I mean, the Sixth Amendment is a bedrock principle of our country, and I think to not give people adequate defense is, even if you are considered a law and order prosecutor, prosecutors like having good public defenders on the other side of that case. And to have them as robust in rural areas as you might have them in our state, Louisville has their own system. It's tied to us. We fund it. Louisville has their own system. They've had it longer. It grew out of our largest city, and now we have them all over. And our governor, again, a conservative, just went, I think, above and beyond what he had to do in terms of, sounded like a TSA urn. Just remember that if you read that. It sounded like it, just like that. Google that one, too. You'll laugh later when you do. Or maybe not if you're the family of the woman whose ashes were in the urn that fell over at TSA. I just gave it to you, the punchline. To you, I think the crucial thing, what our governor did to get back on track was fund more positions to get us up to a reasonable baseline, which is in this budget climate was a very, bold move, I think, by him. But we feel that coverage of our entire state is very critical, and it has incredible benefits to not only pretrial detention, but just ultimately justice.
Next question.
Hi, Danielle. This is for John Bauters. I don't know if I'm saying your name right. This is you spoke about crime victims and how they want more holistic and not people going to jail for a long time. Do you have any studies or where you're getting that information or research or articles on that I could go to? Okay.
Yeah, so I work at Californians for Safety and Justice, and recently we had a spin-off national organization we created called the Alliance for Safety and Justice. We're working in several states on a variety of criminal justice initiatives and reforms, and we did a study last fall where we spoke to crime victims across the country, and I can get you a copy of where that report is online.
New York City actually has a commissioner who works with crime victims. It's quite a unique post. I can give you the name and how to contact her.
You mentioned that you thought there was still some momentum for ending cash bail in Kentucky. Could you talk more about what that momentum is and what it would take to accomplish that?
Absolutely. So, in the early, mid '70s, Kentucky had bail bondsmen like everybody else, and thanks to a political fight, governors in Kentucky used to be like Louisiana governors. That's another thing we have in common. They used to be all powerful. So, when the bail bondsmen took on this governor and he won, again, they did not predict he would win. He told him he'd get him back, so he did. He eliminated bail bondsmen, which set the stage for Kentucky to have this unified pretrial system, much like the District of Columbia's. And so, with that backdrop, I think legislators and the public, not so much the public, but legislators continually hear this drumbeat of this gold standard, the fact that we have this great infrastructure in place. We enhanced it. I've sponsored some legislation to use more risk assessment, to get more people out pretrial, to get them released if they were low to moderate risk offenders. But here's the statistic that counties have to grapple with, which provides that momentum to your question. In 2016, there were 37,000, as adjudged by the court system, our administrative office of the courts, 37,000 low to moderate risk offenders. Sharice may have a better number because the work in Kentucky they do is incredible. The 3 Days Project. You heard about that yesterday, I assume? You hear some about? You didn't? Well, 3 days. Is it 3 days count? Is that what it is? I mean, look that up. I won't go into detail, but the work they do is incredible, and we're thankful that they're in our states. That's another momentum, a game-changing thing for us, for them to be present and talking about it. The Arnold Foundation's been there with the PSA. You can look that. But ultimately, when you've got 37,000 offenders, low to moderate risk, serving an average of 109 days in jail. So public safety would dictate, if you use evidence-based risk assessments, to say these people aren't a threat to public safety. But because there's some low cash bond that they can't make, and they're sitting in a county jail on the county dime, and a lot of our counties are struggling. We have some very affluent areas. We have some very, like any other state, I guess. But these counties some of them are near bankruptcy. Yet they're keeping people behind a jail wall for just a few bucks. These low-level bond amounts. And people get that. And they get the concept. Legislators are getting closer. The real opposition comes from judges who think they're having their discretion removed in terms of a release decision, that there's some risk instrument that's going to make me, some machine that tells me I've got to release this person. When the reality is this, the research is very clear. The best decisions come from using science along with professional discretion. So I've tried to make sure that judges understand. Nobody's suggesting that they have to give up their discretion. We've talked about the use of good, sound judicial discretion. Use your common sense. You can deviate. Put your deviation on the record and say, the reason I'm not releasing this person and I'm detaining them is because of this. And hold them to account for that. But this judicial opposition is crazy. And Sharice has a point which I'd love to hear because please give her a mic.
Well, no, John, actually, if you could just address the issue of preventive detention.
Right.
The problem in Kentucky for not being able to get rid of bond, and in many of the states these reporters will be reporting in, there is that glitch. If you don't have a way to provide due process detention, so judges can activate that like they do in New Jersey and in D.C., they are using high bond amounts to effectuate detention, which is why the money bond system kind of has to stay in place if we're not able to give the courts a legal way to detain the 1 or 2 out of every 100 that need to be detained.
Well, and
Maybe talk a little bit about that preventive. What is the likelihood in Kentucky of legislatively moving? A constitutional amendment. This is all stuff that's happened in New Mexico and in New Jersey that needs to happen in Kentucky.
I think that's the way we want to make it happen, like it's happened in those states. So to answer the question and to those keeping notes, if you look at, we're not going to ignore what's happened in those states. In fact, whatever we are building looks like those two. I think any package that would eliminate the majority of money bail or go to more of I just call it, a public safety-based system instead of a money-based system, would include preventative detention. Obviously, to not only, I think, to judges, but to legislators and their communities, you have to sell that some people who do pose the greatest risk to your community should be preventatively detained if they meet certain criteria. Now, the Rubik's Cube is where is that line, and who do you want to detain when they're innocent until proven guilty? So that's what makes it difficult. But Sharice, I hope I'm answering the question. I think Kentucky will undoubtedly have that in its package moving forward. I do think there are talks ongoing now with prosecutors and judges to build this system. And there's a group in Kentucky made up of sort of a prosecutorial think tank that's behind it as well. I think they're building some momentum for it. And I hope, and there's a number of judges that are very much for it, but there are some judges who have friends in high places who are opposed and are still can't get over this idea that they're having their discretion taken from them, which again, I would make an argument that right now many of them are violating the existing law, some legislation I sponsored, which said you will release these low to moderate risk offenders, maybe under certain conditions, and you have your discretion to vary from that if you, again, articulate that on the record. But the presumption is you release these people. But instead, there's litigation in Louisville now over this very concept that they are holding people that they are duty-bound by the law to release. And so, again, that's why you have the 37,000 people serving an average of 109 days in jail, which, by the way, using just a per diem that we use in Kentucky, that's a $125 million cost to counties. Now, for a state like California, that's a drop in the bucket. To the 4.5 million people in Kentucky, that's not.
Deborah?
Hi, I'm Deborah, and I cover the Deep South. You talked about the rhetoric around criminal justice reform in D.C. Can you speak to the political realities of seeing any of those measures actually getting through Congress this year, and how does that momentum transfer or translate into what's happening in the states? Do we really see a lot happening there, and what that means?
Me or start with yeah. I'll just be brief, and then we'll hand it off. I think as to that rhetoric, I think so. Was it the question more or less? And I apologize. I think your question was clear, and I got wrapped up in maybe parts of it, unbundling it. So. Yeah. Yeah, at the federal level. You know what? I haven't checked in lately on, for instance, the Representative Collins' First Step Act, but I do believe, and I know there was some talk of it being maybe, some on the other side of that debate that want more. We're going to build resistance to it, and that's what you're speaking of. I think the latest that I've heard is that it's still moving through the process. I do think, the administration gave it a bump with the event that was held at the White House and showed people coming together from the left, the middle, and the right to embrace this concept first, and then maybe try to go further as we go along. And I think within the administration, there is the Jared Kushner's office of American Innovation, and the hiring of Brooke Rollins there from the Texas Public Policy Foundation, which houses Right on Crime, which has actually spearheaded a number of good justice reform efforts. They've been helpful to Kentucky. Mark Levin heads Right on Crime. So I think within that backdrop, I think there are real things happening at that level. Again, politics aside, leave them on the shelf and other issues for a moment. But in this space, I believe people are wanting to come together. I do believe it's sincere. I've been on the inside to watch it. I was one of the only Democrats on some of these calls, and I do think it's very sincere. And I think it comes from to my Republican friend here, who I've dealt with. I think there's a common bond with all of us. I mean, these are human beings, and there's everything but from compassion to common sense at play here. I don't think we see these things that differently. I really don't.
My sense is completely in line with what John expressed. I think that there's the perception that I have is that there is broad bipartisan understanding and support in this area, and I don't know the specifics of maybe what's going on in Congress right now with this First Step Act. But the last I heard, I believe it received a favorable recommendation or was moving along, was working through the process. And I think that there are, in any objective review of the progress that's been made in the states, would render conclusion that these policies are effective, that they are helping to save and transform people's lives in important ways, and that also there's immense cost savings that result. And with all of that in mind, it's a common sense policy which I expect will be embraced on the federal level.
What we haven't seen on the federal level is a recognition, even though the feds have no authority over jails, that the two issues are in many ways combined. We've already seen state prison inmates referred to local county jails, And the idea, going back to the systemic problems of the justice system itself, we haven't seen that yet reflected in any federal rhetoric or rhetoric from the Department of Justice.
Well, I'll just briefly, in Georgia, we're a little bit different where we have tried to have the most significant severe offenders, state prisoners, remain in state prisons in Georgia. And so our county jails are utilized for mainly on an increased level because of criminal justice reform, only because individuals who used to be sent to prison are now not being charged with those felonies. And so any sentences are being served locally, and they're not state sentences as we classify them. So I would just maybe have that one distinction. But my sense, again, is that that there is a willingness to embrace the great approaches that have been seen in the different states, and that success stories that we're hearing, like at this conference, allow for additional ideas and the furtherance of those successes in other states.
I would just add in 10 seconds that we house 12,000 of our 25,000 in county jails, and they're our lowest level felony offenders, what we call our Class Ds, a handful of Class Cs.
You know, the thing that happened in California related to the discussion about where we're going on these things was pretty interesting. Since 1980, California built 22 prisons in one university. Since 1980, okay. If you study policy in other areas, okay, like traffic, for example, you build highways, okay, we call that an inducement. When you build more lanes on freeways, more people will drive. It doesn't actually solve the traffic problem. It actually just makes it a bigger traffic problem. The same thing happened in California. We built all these prisons. We put all these people in them because now we've got all these prison guards and prison guard unions and people who have jobs that need to be paid to do something because we built this infrastructure complex. Okay, it took a court decision, actually, in California called Plata, a court decision to say that the overcrowding of the California prison system was an inhumane, unhealthy, unsanitary, and essentially a criminal situation. Okay, and it gave the California legislature and the governor basically directives. We're putting you under receivership, and unless you decrease the state prison population at these benchmarks over this period of time to what they kind of artificially determined to be a safe level, we're basically taking back over, and we're going to just start releasing people. And it forced the state to have that conversation about what changes need to be made. And so one of the things that happened in California, and I applaud other states not wanting to build more prisons, because I think that's the wrong direction to go. We're trying right now, my next task at my job is, I've been basically given a 3-year plan. I need to close a prison in California, because that's where all the real money savings comes, to reinvest in all those collaborative courts, mental health care. That's where all the money is closing a prison. And so we're down to 2 states. We had contracts in a half dozen states for out-of-state prison beds, and we're down to contracts with Mississippi and Arizona. We intend to have no inmates in Mississippi by the end of this year, and we intend to have no inmates in Arizona contract beds by the end of next year. And then we have a couple private prisons in California, and the state's next objective after that is to close those private prisons down, which would, by doing all of that and a couple other things that's required by the court order, would get us within the compliance of the court's ambit of what we need to do. The consequence was that a lot of these reforms, we talked about AB 109 was the legislation in the 2011 Public Safety Realignment Act in California. It moved a lot of prisoners who had nonviolent felonies to the custody of the county jail. So now there's this pressure on counties are facing pressure from their local sheriffs to build more jails, build more jail beds, increase jail spending. Okay, again, the wrong direction to go. And it's that narrative, that local discussion that we're all having here and that you're participating in about what do we do, what reforms do we make locally, because the state was induced by the courts to do it, but policy is what's going to really change the way we handle jails and jail beds and prioritize. Does this person walking in here who's been here 4 times this year because they're a heroin addict, do they really need to be in a jail bed, or do they need to be in a treatment bed somewhere else, right? And how do we prioritize and make best use of our resources that way? So I think that there are some counterbalances to some of these things, even at the federal level, because the federal level has consequences for states as well, and it really gives us an opportunity to talk about how do we make the best use of all the resources and all the systems that we manage that influence one another.
Let me just say our governor's gone on record saying we will not build a prison under his watch. Well, again, he said that early on at a State of the State speech. I will add that since 2011, thanks to that legislation I mentioned, we've closed 4 adult facilities, and we had juvenile legislation that followed that up. And again, juvenile justice under our cabinet now. We've closed 4, and I intend on closing 2 more juvenile facilities. We've cut our population in half based on the same justice reinvestment principles we're talking about today. And that's an easier political sell when you're dealing with children, but it still was a tough slog to get through the schools and dealing with administrators at that level and judges. But we've since in Kentucky, the juvenile has held, our reductions have held. The adult side is ticking upward, as I've told you. We've had to reopen 1, and we're looking at maybe having to reopen another of those 4 we closed. So that's a tough thing for us going forward. But our governor is committed to reducing the population. But when you have a legislature that continually rolls back, there's one bill in particular that's going to add 35 million and several thousand inmates to our projected count over the next decade. So it's that kind of, again, in my opinion, against the grain, against the national trend legislation that is harmful that we've got to push back against.
Question over there and
Hi, Rose Schneider from the Altamont Enterprise. I had a question for Chuck Efstration. You mentioned, I think it was a few years ago, you passed a ban the box bill, and I was wondering if you've seen any effects in the last few years from passing that bill on recidivism.
So that was done in our state administratively. It was for state applications to jobs. There was also great cooperation with the business community to encourage businesses to voluntarily get into it. What mainly we've addressed is record restriction, in some states expungement, and it's taken this form. Sometimes there were circumstances where paperwork wasn't being submitted to the judge to facilitate that, so legislatively we addressed some of that. In other circumstances, the process was just too arduous and the circumstances were difficult. And I think that specifically in that legislation, which passed several years ago, it was necessary to have greater understanding from the media as well, frankly, as we were working on that legislation, because we're talking about restricting records and restricting access to records. And for journalists to understand the necessity of that, I think was a great partnership and cooperation to be able to explain that to the public throughout those discussions. Similar also with available arrest records online, which once they're on the internet can never be removed. Their offshore companies are holding them, and all it takes is an employer to Google the person's name, and that pops up. And so now there have to be reasonable, bottom line is we have provisions in place where if you're running a story, you'll get the material that you need so that you can, including book and photos and things like that, but that it's not just widely available so that offshore bad actors who are, say, pay me to take down this picture that we've posted, they're not, that conduct isn't facilitated.
this one right in the middle. Yeah.
My name is Elisa. I'm a reporter in Southwest Missouri. I had a question for John. So earlier you mentioned that to sort of communicate with these more rural conservative communities, you have to be able to use a language that people locally understand. And I think you gave the example of focusing on narratives that involve families and children. Can you elaborate a little bit more and talk about what sorts of language you've found effective in your own communities?
Yeah, there was a speaker in the prior panel who I thought did a good job of raising just a couple examples. And one of the words that is a sensitive word, I think, is when we refer to people as an offender. And we've done it up here because it's common speak in the practice, I think, of where we're from. But when we refer to people as an offender, imagine if, or a felon. That's my least favorite one. When we refer to a person as a felon, imagine if you were only called by a noun that described the single worst thing you did in your life. Imagine that. Imagine if you were called adulterer or cheater or liar everywhere you went. Now imagine what your prospects are if every place you go you're referred to as a felon. And when the media refers to you as a felon, it has already, by doing so, prejudiced what would otherwise be an open-minded person or a receptive reader's potential understanding of the human components of that person's life.
So ex-felon doesn't do it.
Ex-felon does not do it for me. It does not do it for me.
Returning citizen, how's that?
I worked in the homelessness field for a long time, and there was a lot of people who said, "Oh, homeless people." Okay, homelessness is a state of existence. People experience homelessness, right? So we don't refer to them as homeless people because it would be like referring to someone as a white person or a black person, something that's immutable to them. I think it's really important how we actually describe the people we're talking about, as a parent, as a child. And one of the things that's like very important to me is that many of the people who we see, who we read about who've committed a crime or who are accused of committing a crime, in their any age, but especially at adolescence and in their early to late 20s, okay? Most of those people are victims. That's a statistic that you can't ignore. Most people who commit crimes in young adulthood are victims. And so I'll give you a really good example. I had a witness for a bill hearing. I do between 4 and 6 bills at the California legislature every year. I had a witness for a bill hearing who, if you were to take what the media said about her, she would be a felon, an 18-year-old felon. But this is what most people didn't know about her, was that at the age of 9, she witnessed her father murder her 5-year-old brother. Okay? Her mother died of a drug overdose as a consequence of mourning the loss of her brother. Okay? She spent time in 15 foster care homes. She never finished high school. She was never offered behavioral health care, medication, therapy, or any type of treatment until 6 years after the event. She was forced to testify against her father at her own father's murder trial. Okay? She basically testified at a hearing that she spent about 6 years of her life in a haze, drug-induced by medications prescribed to her. She was found unfit at foster home to foster home. She engaged in prostitution, which to me isn't prostitution when you're a minor. It's actually you're a sex trafficking victim. She participated in other types of activities that we would describe under California law as criminal. And so she obtained a conviction on her record. And after that, everyone referred to her as a felon. If you stopped reading there, if you identify the person for the worst thing they've ever done and not the most sympathetic thing that they've ever experienced, you have prejudiced the community's understanding of what's really going on. So those are the types of examples that I would give in a nutshell here as to how we talk about the issue, because I think it really matters. If you're trying to get someone understands differently, a child who was abused, who witnessed a really horrible event, who's gone through a lot of negative experiences and not had adult supervision or assistance in their life, they understand that person and are more willing to show compassion towards them than they are if they're referred to as a criminal or a felon.
I think one of the underlying takeaways here is not to stop with a descriptive word, because the problem with changing descriptive words from felons to returning citizens, they very quickly become catch-alls that end up with the same code that you wanted to avoid to begin with. But really, it's the stories that matter.
That's exactly right. It's not just the word.
That's really what we're talking about here.
It's
is
the narrative of the person.
How you call them in a headline or not, it's always an editorial problem, but it's the story that really counts. I think.
Yes, I agree with that completely. It's not down to the semantics of a single word, but I do think it's important to recognize that single words do influence the way people identify or think of things. Yeah. And it's important to tell a person's whole story to help people understand the context with which they're living in.
I think we have time for one more question, maybe two if it's quick. Or are you ready for lunch?
I'll tell you this real quickly. I think it's one of our western states. I can't remember, South Dakota. She does a great job. She's a corrections commissioner, and I won't name her because I can't remember. But they refer to inmates, refer to the inmates as residents, and I something I wanted to think about doing, and I asked an inmate I'm working with on another project who's gone on to incredible success after talk about a story that would be an incredible movie. But this gentleman said to me, "It doesn't matter what you call us. We are what we are while we're there," and that kind of. So there's two. I actually agree that words matter, and we should, especially when as it relates to addicts. You call somebody an addict for the rest of their life. Even a recovering addict, they become that and nothing else. Even though a lot of times they are very open and honest about that. But this guy told me, so it's interesting to get the different perspectives.